Please report. Can I start just by picking up a couple of references which I can do quickly and orally? The first one is a question about whether the tribunal can grant temporary admission. The answer is no. The answer can be found in Authorities 1, tab 4, at page 107. It's paragraph 21 of the 1971 Act. It's MS 723. 723.
Thank you.
The other one that I can deal with quickly is the basis of SAIC's Hardiel Singh decision in this case. That is in Core Volume Tab 9 at page 55. And that is MS 263. Starting at paragraph 48, there's a section of our conclusions on the prospect of return. And so the reason, or what SAIC sets out there starts with that. And then when you go over the page to 51, there is a final conclusion is that no reasonable prospect of removing the appellant to Algeria, and thus the ordinary legal basis for justified detention has fallen away. So in this particular case, that was what was reached.
Happens to be that, yes.
Yes, but it's clearly the Hardiel Singh point and not the Kadir point, if I can put it like that. Returning then to the old cases, my reason 6, can I just, as a final point on Yusuf Uddin, draw attention to what B's printed case says about this. This is Core Volume Tab 7 at page 33. It's MS 4257.
Paragraph?
It's paragraph 89.
Thank you very much.
Paragraph 89. It follows section states citation of Yusuf Uddin as authority for the proposition that bail does not constitute imprisonment, entirely missing the point. And then it goes on, it is not bail itself that is in the imprisonment, or not necessarily so. It is the validity of the underlying authorization for detention which could at any time bring it about that is important. And now that we've actually seen the case, it is absolutely right that bail doesn't constitute imprisonment, and by 1903, the old concept had gone away. B appears to recognise this here. And then the second sentence referring to the underlying authorization for detention. Well, of course that's right. If B or Mr. Uddin were ever to be re-detained, there would have to be a valid authorization for detention. In the immigration context, there would be further authorization for it. It would either be the lawful exercise of the power of arrest or the tribunal's order that he be detained, or the Secretary of State might authorize further detention after that. But as far as B is concerned, or anybody in his position, while he's on bail, there is no authorization for detention. That's just simply academic. And so we see this misconception appearing again here. There are two more cases that I need to refer to in relation to this old cases section. The first one is not an old case at all. It's the case of Stellato, but it illustrates how far we have come since those days of the 1700s and before. Stellato is at Authorities 2, tab 14. It's MS 1084. Without turning it up, I should just say that in our printed case, we identified a very pithy summary by Mr. Justice McCloskey in Northern Ireland, where he said Stellato's authority for the proposition that bail is the antithesis of detention. That's exactly how we put it. But it is worth having a look at what happened in Stellato. The facts are probably easiest to take from the headnote at MS 1084. You will see that the original dispute was concerned his release on licence. Mr. Stellato contended that he was entitled to be released unconditionally rather than on licence, and he refused to comply with the terms of his licence, so he was returned to prison. The divisional court dismissed his claim for judicial review on that issue, and then on the 1st of December 2006, the Court of Appeal allowed his appeal and granted a declaration that he was entitled to immediate release. But it stayed its declaration to allow the Home Office to lodge a petition for leave to appeal to the House of Lords. The Court of Appeal then granted him conditional bail. The claimant refused to comply with the bail conditions and got himself arrested, and then he was detained because the bail was revoked, and he remained in custody. And then in February 2007, the House of Lords dismissed the Home Office's appeal, and the claimant was released unconditionally. And then he sued for false imprisonment because he said that he should not have been detained because he was entitled to be released unconditionally. In the Court of Appeal's decision on that, can I start at paragraph 21? It's MS 1090. The first argument dealt with was a contention by the Ministry that the stay ordered by the Court of Appeal authorised Mr. Stellato's detention. That was rejected. I don't think I need to go into the detail of that. But on the next page at letter B, Lord Justice Sandy Burnton did observe that the only authority for Mr. Stellato's continued detention relied on by the Ministry before the Court of Appeal was a sentence of imprisonment that had been imposed and the legislation that was the subject of the court's judgment. There could have been no other authority for his continued detention. And then he went on to deal with the bail, the conditional bail that had been granted, referring to my Lord's orders. Lord Justice Sandy Burnton said, "I consider that the answer is to be found in the nature of a grant of bail. In principle, a grant of bail is not an order for the detention of the person to whom it is granted. To the contrary, it is a grant of liberty to someone who would otherwise be detained. The legal justification for his detention is to be found elsewhere." There's reference to statutory provisions. And then at 24, sorry. I'm asked to read the whole of 23. The last two lines, that there is statutory authority for detention in immigration cases, paragraph 16 of Schedule 2 and paragraph 2 of Schedule 3. A grant of bail may be conditional or unconditional. A condition of bail does not impose an obligation on the person granted bail. It is a true condition. It qualifies the grant of liberty made by the grant of bail. If the person granted bail does not comply with the conditions of his bail, he is liable to return to custody. If so, the legal authority for his detention is not the grant of bail or his breach of the conditions of his bail, but the authority for his detention apart from the order for bail. All that his breach of the conditions of his bail does is to disentitle him to bail. So, as clear as it is possible to be, bail, as Mr. Justice McCloskey said, the antithesis of detention. If you're going to be detained, you have to be detained under the detention authority. Bail is not that. And so the wheel, sorry, it's not full circle, it is exactly the opposite of how bail used to be at the time of the old cases that the Court of Appeal relied on.
So that gives context to your answer to my question about paragraph 24.3, when I asked you if someone breaches a bail condition after being arrested by an immigration officer, then you can only return him to detention if you have a power outside paragraph 24 to detain him.
That is right.
Yeah.
But in a case of this kind, the power exists because the power to detain continues to exist.
But its exercise would have to be justified.
That's right.
On Hardiel Singh principles.
Exactly so.
And you claim the breach of the bail condition might be relevant.
Exactly.
to that regard.
Exactly.
But it might be completely irrelevant as well, depends what the condition was.
Oh, that's right. It might be completely irrelevant, and we might then find that the person actually cannot lawfully be detained, even though he'd broken his bail, and he would have to be re-released on bail. Yes, I entirely accept that. Yeah. And so you have to look at it as they are.
Thank you.
So Stellato, they're showing the modern position. It is now absolutely crystal clear, and it supports our point that the Court of Appeal was, with respect, misled by this old authority. But Stellato actually goes just one step further than that for my purposes, and that is this, that it is an example of the Court of Appeal granting bail to a person to get him out of detention when it had already held that the person's detention was unlawful. Because the Court of Appeal was, in the end, agreed with by the House of Lords. Detention was unlawful because Mr. Stellato had been entitled to be released unconditionally. And yet the Court of Appeal thought that the appropriate response was to grant him conditional bail, pending the resolution of that. It may be that the analogy cannot be exact, but it does support our point, which I'll come to under reason 7, that is all of the piece with the approach that courts have taken to anxious cases like that, where in this context, dangerous criminals who can't be detained any longer have to be released. The best way of doing that is release them on bail, and you can then manage the conditions appropriately. The final case in this section is a case of Armand, and that is Authorities 2 at tab 5. It's MS 833. Can I just draw attention to the facts of this rather unusual circumstances during the Second World War? From the headnote on the first page, on the 8th of August 1940, a decree was made by the Queen of the Netherlands imposing compulsory military service on all Dutch subjects of a certain age residing in the UK, US, and in Canada. And the applicant was called on to report for military service and did so under protest. He was given a week's leave in February 1941, but did not return, and was subsequently arrested by the police as a deserter from the Netherlands Army. And then he applied for habeas corpus. Now, of course, if he had remained in custody, habeas corpus would have been a perfectly good remedy for that, and nobody would be arguing that there was anything inappropriate about it. This, of course, being 1941, was long before the modern judicial review procedure. And so it may well have been that habeas corpus was the only way in which he could have the lawfulness of his arrest and his liability to compulsory military service tested by the courts. And it's in that context that there was the observation made by the court at page 249, MS 843, about 7 lines down in the Chief Justice's judgment. He says the applicant has lived in the UK for a number of years. On 14th of March 1941, arrested and detained in custody for the purpose of being handed over to the Netherlands military authorities as a deserter. He is now on bail, but this makes no difference, and we have to deal with the application as if he were still detained in custody. And this was one of the cases relied on by the Court of Appeal as demonstrating that if you're on bail, you are to be treated as though you're still in custody. And our answer to that is actually very straightforward. There was an issue to be determined. The form of the proceedings was an application for habeas corpus, which is classically, at least these days, for determining the lawfulness of your detention. And that is what the court still had to decide, although they granted him bail in the meantime. That observation about them having to deal with him as if he were still detained in custody is no more than identifying that that doesn't change the issue that the court had to deal with and decide within that within those proceedings. And so that was a case which really goes nowhere to supporting the Court of Appeal's views. And so in summary, one can see that these old cases really ought not to have been relied on at all. I'm not going to say that the old cases positively support my case. That's not what we're saying. It's just that they are a red herring. And we respectfully invite the court to say so and to decide the case on rather more conventional lines. Can I then turn to reason number 7?
Just before you do that, Mr. Tam, could I just ask a question about a different bit of not particularly old law, which, if no one's looked up yet, please do it later. But I better raise it because I've just been wondering about it. Police bail. Where somebody is charged, they are in effect going to be handed over to a court. It's not that I'm thinking about. I'm thinking about people who are arrested, interviewed, and then the inquiry is proceeding. There is a system, and has been for many, many years, for the police to grant bail, is there not? Does that throw any light at all on the underlying proposition that we're being asked to confront, which is that the grant of bail assumes a power to detain? I think it's probably now in the Police and Criminal Evidence Act, section 47 or thereabouts, but I don't know the answer, and I just thought I'd better raise it in case anybody else did.
Well, Lord, I'm afraid I don't know the answer off the top of my head. May we look at that over?
Of course, thank you.
Reason number 7, which is, well, I think I've already explained this, that as a matter of practice, without this issue having been argued before them, judges have long understood the position to be as we have contended. That is to say, when detention becomes unlawful, then you can grant bail, and moreover have regarded bail as a useful tool when detention becomes unlawful in a serious case. Can I, without going through them in detail, identify the cases that we have cited in our printed case? Bashir, and I think these are in chronological order. Bashir, which is Authorities 5, tab 49, MS 1963.
So could you refer to the passage in your case?
Yes.
So that I can just add Bashir, I think, is 93, is that right? Paragraph 93, MS 4258.
No, it's in our case, which is...
Oh, sorry, that's your case.
Yes, it's
Yeah,
MS 164. So it's tab 6, page 45 of our case,
Yes,
starting
I'm
at MS
grateful.
164.
I remember there was a list,
Yes.
enumerated list, that's right. So it's tab 49.
Tab 49, MS 1963.
196.
That was Mr. Justice Mitting. He also gave the judgment in the following case, A, which is at Authorities 4, tab 36, at MS 1469, 1469. Then there's a case of O, decision of Frances Patterson QC, as she then was, Authorities 6, tab 70, MS 2520. The next case was a case called Adewale, a decision of my Lord Lloyd Jones, sitting at first instance then. Authorities 4, tab 37, MS 1482. There's Wang at Authorities 8, tab 96, MS 3314. Then the case of D, I should say that was Mr. Justice Mitting. And the next case is D, which is a decision of John Howell, QC, authorities 5 tab 51 at MS 2027. Ahmed, authorities 4 tab 38 at MS 1490. Decision of Mr. Justice Langstaff. Then the last two in this list are decisions of Mr. Justice King. First of all, Hussein, authorities 5 tab 57, MS 2182. Then HY, which is authorities 5 tab 58, MS 2198. So there's quite a selection of different judges and deputy judges who have all taken this approach. Our printed case summarises some of the facts of these cases, and for that reason I'm not going to go into them. And we say that shows this wide understanding that is consistent with our case. We also cite in the national security context the case of Q, which is at authority 7 tab 75, MS 2628. Now, we cite this for a slightly different reason, because I don't think that the judgment of the court makes any observations on it. But at paragraph 12, which is MS 2631, there was a concession made by the counsel for the applicant in that case, well-known, very experienced immigration practitioner, Ms. Webber, which conceded, or I think it was a suggestion from her, that one of the layers of remedies, if the court were to find that detention was unlawful, was grant of bail on strict conditions. So that the understanding shared by at least some of the bar at that time. But the one case which I think I do need to show you, because it's a bit complicated, is the case of Draga, a decision of the Court of Appeal, which is at authorities 5 tab 52. That's MS 2041. To set the background for this, can I first of all please go to paragraph 3. This is MS 2042. Mr. Draga, Kosovan national who claimed asylum, was recognised as a refugee and granted ILR in 2001. And then skipping on to paragraph 13, you see that 5 years later, he was served with a notice of decision to deport because he'd been convicted of possession of drugs with intent to supply, and the Secretary of State was proposing to deport him as conducive to the public good. At paragraph 16, you'll see a note that he appealed against the decision to make against that decision to make the deportation order. At paragraph 17, it was conceded by his then counsel that the offence of which he'd been convicted was one specified by order as a particularly serious offence. And that litigation then proceeded, and eventually he was unsuccessful. You'll see that at 21, there's an observation that the Court of Appeal refused his application to appeal out of time. So the first round of litigation was then at an end. Mr. Draga then made further representations on the 20th of March 2008. They were refused in June, and removal directions were set for Kosovo. He then applied for judicial review, and the proceedings were then stayed behind the case of EN Serbia. See that paragraph 23. And in EN Serbia, the Court of Appeal ultimately held that the order specifying particularly serious offences was unlawful and ultra vires. And so at paragraph 25, you see the Mr. Draga's representatives contending that the original decision to make the deportation order and the deportation order itself were unlawful because they were wholly reliant on that ultra vires order. At paragraph 26, the Secretary of State refused to revoke the deportation order. The Secretary of State said the deportation order should remain in force because of his serious conviction and because he fell within the terms of Article 1C5 of the Refugee Convention due to the current situation in Kosovo. So that's a reference to the cessation provision of the Refugee Convention. At 27, you see Mr. Draga appealing that refusal to revoke the deportation order. The tribunal allowed his appeal, and it said, tribunal found it was clear that the respondent was relying on the 2004 order. EN Serbia has found that order to be ultra vires and unlawful. Tribunal found the original deportation order that depended on the lawfulness of ultra vires subordinate legislation is unlawful. In the light of the above finding, tribunal find that the refusal to revoke cannot be upheld. If the original decision is not in accordance with the law, then the appellant is still a refugee with ILR. Tribunal found that the cessation order was made as a device by the Secretary of State to deport the appellant, faced with the fact that he could not rely on Section 72(4) and for no other reason. Cessation order was pursued in the face of an inability to exclude protection without realising that this inability rendered the original deportation order nullity, and therefore the decision to cease the appellant's refugee status was unlawful. And as the Court of Appeal in this judgment later held, Mr. Draga's detention was therefore unlawful from the point that the cessation order was made, because it was a device and the Secretary of State shouldn't have used it.
Where is the cessation order?
I think it's a reference to the decision in paragraph 26.
Yes, I see.
Now, don't need to be concerned with the ins and outs of the unlawfulness of the detention. For present purposes, what's important is that this next paragraph, that on 17th of September, the Secretary of State sought permission to appeal, and on the 30th of September, the First-Tier Tribunal refused that application and granted bail to Mr. Draga. So you see there the tribunal, and the tribunal that's going to bear the brunt of all of this, also sharing the view that here you've got a man who's the subject of a device to try and maintain deportation that's actually unlawful. And the response is, let him out on bail. So we respectfully say that that is all of a piece. This is a useful power to have in exactly these circumstances. So that completes the 7 reasons, and it leaves only the Article 5 part of the case. As I think the Court is aware, Article 5 has not been raised below, and in our printed case, we've set out some basic building blocks in relation to Article 5. And at this stage, I think it's probably efficient if I do no more than just advert to them. We, of course, accept that Article 5 restricts the situations in which a person's liberty can be interfered with to the point of deprivation, and Article 5(1)(f) is a specific provision that deals with immigration detention. However, there's no difficulty with that because our argument that all of these powers cease when there is no prospect of removal is all of a piece with what Article 5(1) permits and doesn't permit. The second building block is that Hardy or Singh lawfulness is, in general, compatible with Article 5. That's the case of JN and the United Kingdom. That is at Authorities, Volume 9, Tab 102. And in particular, paragraph 97 at MS 3510. There is actually quite a lot of detailed consideration of various elements, but Hardy or Singh gets quite a ringing endorsement from the Strasbourg Court. And we do, of course, accept that if bail conditions amount to a deprivation of liberty, as they can sometimes do, then the procedural requirements of Article 5 will be applicable. The clearest example of that is a case before SIAC in which the Secretary of State opposed bail on the basis of an existing SIAC judgment, open and closed, about what the individual had done, but didn't want to go through the disclosure obligations that are inherent in Article 5.4. In that context, it was held in the case of BB that Article 5.4 standards do apply to a bail application in that context. The reference for that is Authorities 5 tab 47 at MS 1934. So all of that is compatible with Article 5. And of course, the final string to this bow is that in practice, as I think is common ground, the person granting bail, particularly the tribunal, can have regard to whether detention is unlawful, has become unlawful, or is about to become unlawful, even though it has no jurisdiction formally to decide the question. And if it can consider that question, the closer you get to unlawfulness, the more likely it is on the current understanding that the person will get bail. And so that is all consistent also with Article 5. And so we respectfully say that there is nothing wrong with that. If there are any points on Article 5 which I need to make in reply to my learned friend submissions on that, then I'll ask if I can do so at the appropriate time. But unless there's anything else on which I can assist at this moment, those are our submissions in opening.
Thank you very much indeed, Mr. Tam. Thank you. Ms. McLean?
My lady, my lords, we respectfully submit that the Court of Appeal was entirely correct in concluding that the grant of bail, which is release from detention, requires that the underlying power to detain not only exists, but can be lawfully exercised. And that if detention cannot be lawfully exercised, there is no power to impose bail and conditions of bail. The statutory scheme provides for the alternative of release on temporary admission or on temporary restrictions, that there is a clear and material distinction in the statutory scheme between the word detained, which is the basis upon which the bail power is predicated, and liable to detention, which is the statutory precondition for release on temporary admission. Court of Appeal were entirely correct to identify that as a material difference and to reject at 27 to 29 Mr. Tam's reliance on the House of Lords judgment in Kadir as effectively being appropriate to read over when one is interpreting the very different word detained from liable to be detained. The fundamental proposition of the Court of Appeal was that bail presupposes lawful detention, and we respectfully submit that that's not only plainly correct, it is the long-established position under the common law, and that common law position is reflected in the jurisprudence of the European Court of Human Rights when considering Article 5, and in particular Article 5.4. We respectfully submit that Mr. Tam's approach and invitation to this court to adopt a purposive approach to these statutory provisions, the key provision being what detained means, is entirely wrong, that it's well established that when one is construing powers of detention and what it means to be detained, and we would also respectfully submit release from detention on bail, including on very strict conditions which may well amount to a deprivation of liberty, the court must adopt the strict and narrow construction in favour of liberty that has been long endorsed by these courts. We also evoke, and we say the Court of Appeal did so properly at paragraph 34 of its judgment, that it would be extraordinary for Parliament to have intended that the power to impose severe conditions, albeit in the context of bail, effectively on an indeterminate and certainly on Mr. Tam's case indefinite basis, subject only to the long stop of there being no prospect at all of removal, would require the clearest of statutory terms, or would inevitably and by necessary implication have to be implied within this statutory scheme. Mr. Tam's submissions, we respectfully submit, at its best rely upon silence and ultimately require the implication of the words unlawful or lawful or unlawfully, at the very least, into the statutory scheme in order to make good his propositions. We respectfully also submit, as the Court of Appeal properly rejected at paragraph 36, that reliance or resort to purported undesirable consequences relating to risk management and or suggested impracticability would not be a basis for concluding a different interpretation of Parliament's intention or the clear statutory words. We therefore submit that the Secretary of State's invitation to overturn the Court of Appeal's order and declaration at paragraph 3 that bail can only be granted where there is an existing lawful power to detain would lead the court into adopting a construction that's at odds with the statutory language, adopt an impermissible purposive construction on the basis that it would be either sensible or covering useful ground, which is the language that the Secretary of State's case uses at CB6 MS 127 2.7. It is seeking, in effect, to utilise bail powers which are designed to ensure that a person surrenders to custody so that the underlying immigration power can be effected for a broader risk management purpose disconnected from the immigration purpose, given that this case is predicated upon there being no prospect of removal within a reasonable period of time. It's that disconnect from the statutory purpose and the use of the machinery of deportation that we say is impermissible and is an inevitable and necessary consequence of the Secretary of State's argument. And we do maintain that it is a construction of the 71 Act which does depart in fundamental ways from the concept of bail that has been recognised for a very long period of time and in this country and in respect of the law relating to habeas corpus. We also submit that the approach is contrary to Article 5.1 and 4 of the ECHR, and therefore we evoke the interpretive obligations in Section 3 of the Human Rights Act in support of our submissions. Mr. Tam has identified 7 reasons why the Court of Appeal were wrong. We have formulated our submissions essentially under 4 headings into which his 7 headings fit. But the first and critical issue is the statutory language. Then consideration of the Secretary of State's arguments on purposiveness, practicality and absurdity. Third, we would then address the position under the common law, and lastly, Article 5 of the ECHR. Before addressing those issues, can I make some preliminary observations on the facts? And it is important, and the court was keen to understand exactly the basis for the conclusion of the Court of Appeal at paragraph 23. If we can just turn up the Court of Appeal judgment, which is CB9, Appendix 1, MS page 222, para 23. And essentially, the starting point in this case is, of course, the ruling of the Special Immigration Appeals Commission on the 13th of February 2014 that there was no real prospect of removing the appellant to Algeria, and thus the ordinary legal basis for justified detention of B under the Immigration Act has fallen away. That is, as we've seen from Mr. Tam's references just after lunch, that's a reference to paragraph 51 of SIAC's ruling. There is then the second sentence: the Secretary of State accepts that there was thereafter no further authority for the detention of the claimant under paragraph 22 of Schedule 3 to the 1971 Act. And the factual situation there is that the Secretary of State, in response to an application for judicial review, which is ultimately the proceedings that are before this court, although amended to challenge SIAC's judgment, the initial application for judicial review that we brought was against the Secretary of State's continuing, what we understood to be, the Secretary of State's continuing authorization for detention, it being our case that any grant of bail is predicated on the existence of a lawful authorization for detention. And what the Secretary of State told us was that from the 13th of February 2014, i.e. from the judgment of the Special Immigration Appeals Commission that there was no prospect of removal within a reasonable period of time, was that no further authorization for his detention had been given. And if I can just take you to the material in respect of that, the judicial review application is in Appendix 2 at MS 364. And it's the amended document, but you can see from the amendments that which was struck through what the initial judicial review was directed at.
Sorry, Appendix 2.
Appendix 2, my lord, at MS 364.
Our Appendix
copy
2
has it.
doesn't have MS pages. Could you give us the hard copy page?
152.
152.
Thank you.
Thank you.
So you'll
Quite
see...
a drastic change, really.
Sorry.
Quite a drastic change, really.
Yes, we explain that, but essentially, after the ruling of the Special Immigration Appeals Commission, we had assumed that the Secretary of State was continuing to authorize, had a continuing authorization for detention, and but in order to make clear, we sought a quashing order in respect of that. That's at 1A. And then as a result of what happened in the proceedings, the judicial review was then focused upon SIAC's decision. And you'll see at 3A on 153 the declaration that we sought, and the submissions are then at 160. In response to that application for judicial review, the Secretary of State served detailed grounds of defence, and they are at page 333
And could I have the MS number too?
Yes, of course. That's MS 331.
Thank you.
And you'll see the document on 119 or 331, headed Secretary of State's Grounds of Defence. And you'll see at paragraph 7 that the Secretary of State, as she continues to do, disputes our analysis that the grant of bail must depend upon the existence of a continued authorisation for detention. That's at paragraph 7. And 8. Fourth, as a matter of fact, the Secretary of State has not authorised the claimant's continued detention since SIAC's finding that there is no reasonable prospect of his removal to Algeria. There is thus nothing for this part of the claimant's judicial review application to bite on. So that's the context in which the Court of Appeal recorded at paragraph 23 that there's no further authority for detention.
The grounds of defence are at page. I'm sorry, I've
Oh,
my
sorry,
notes.
they are at
Hard copy 119.
Thank you very much.
or 331.
Yes, thank you.
And we therefore say that the subsequent sentence that follows those two propositions is, of course, the starting point and is the basis upon which this court must make its ruling. It's common ground that the claimant could not lawfully be detained following the ruling of the 13th of February 2014, because to do so would exceed the implied limits on the exercise of the administrative power to detain for immigration purposes, as determined in the Hardell Singh case. And in terms of the issue that rests upon that basis, legal and factual, if we go to the Statement of Facts and Issues at tab 5 of the core bundle and to the concluding pages where the issues sorry, at 115, MS 115.
Which paragraph?
43.
And it, it is B, 43B.
Oh, yes.
It's internal 11. And the question for the court is predicated on that basis, whether SIAC has power to grant bail or to impose conditional bail on an individual, whether pending appeal or otherwise, if at that time the Secretary of State cannot lawfully exercise the power to detain him compatibly with Hardell Singh principles. And whilst, of course, in order to test the argument, we could look at cases where the power to detain is resurrected in the way that Malone and Friends suggested, well, if you breach your bail, then that may affect the Hardell Singh balance. But the context of this case is that it is predicated upon the finding of SIAC that the power to detain cannot be lawfully exercised. And obviously there are other observations that one can make, is that, as we've said in our written case, positing a situation where the lawful power to detain is and to exercise that power is resurrected does not address the critical issue that we have before us, which assumes that that power cannot be lawfully exercised.
Will you be commenting on the suggestion that a breach of bail, if bail has been granted at the end of what would otherwise be the period of detention, which was acceptable under Hardell Singh principles, whether a subsequent breach of bail would be relevant to a Hardell Singh assessment? will you be coming on to that at some stage?
I'm going to take you to the statutory scheme where we look at the power in paragraph 24, in particular 24.3,
Yes.
as to when in those circumstances one can re-detain.
Yes.
And my respectful submission is that you cannot lawfully detain that person if you cannot exercise the power to detain.
I don't want to take you out of context. I just wanted to put a marker that I wish.
The existence of the power is simply not an answer
I wish
to that question.
I wish to be addressed on paragraph 24 at some stage.
I'll do that, my lord. What I was just intending to do before I come into to look at the statute is just, because we had discussion about it, is just to fix the basis upon which the Hardell-Singh principle is breached in this case, or the principles cannot be met because of the finding of no reasonable prospects of removal to Algeria.
Isn't that common ground?
Well, it's only because there was, I think it is common ground, but the basis upon which that's incompatible with the Hardell-Singh principles did seem to me to be something of a debate. And if I could just take you briefly to some additional paragraphs in Lumber. We looked, if your lordships go to volume 2, tab 9, we looked at paragraph 22. Where the principles summarised by Lord Justice Dyson, as he then was, were set out by him in his judgment in Lumber. And you'll see at 23 the sole dissent that there was on these questions was from Lord Phillips, but it's in respect of paragraph 24 and the second principle, an analysis of those principles, which I'd ask the court to read. And emphasise that there is here a backstop principle that where you have reached the circumstances in which there is no prospect of removal within a reasonable period of time, that clearly engages principle 2. And whilst, of course, in deciding whether the overall period is a reasonable period, one would take into account factors such as abscond risk and risk of reoffending insofar as they were relevant to the question of the reasonableness of the period. There will be a backstop, however serious the abscond risk and however serious the offending. And Lord Dyson makes that clear in the substance of dealing with Mr. Lumber's case at para 144 D to E, and that's MS page 912. And puts it in stark terms: there must come a time when, however grave the risk of absconding and however grave the risk of serious offending, it ceases to be lawful to detain a person pending deportation. And we respectfully submit that that was the point that was reached as of 13th of February 2014 in B's case.
So could you remind me the paragraph number?
It's 144, my lord, and it's
144,
MS
thank you.
912.
912. Thank
Well,
you.
that entirely accords with what I was saying earlier.
Yes, my lady. I think that's the bottom line. And of course, it means that in circumstances, the hypothetical posited by my learned friend, which is, well, the fact of a breach of bail means that the Hardell-Singh balance has to be restruck, that could occur in some cases. But there will be a category of case, and we respectfully submit on the findings of the court, this is such a case that whatever the circumstances of the breach of bail, it is absolutely clear that B was committed to not providing the details that would have given the opportunity for the Secretary of State to obtain assurances. And that was long-standing and was continued despite the conviction. Now, of course, that's not appealing to the court, but it's the reality of the situation. And it is also underpins why the Hardell-Singh principles are principles of constitutional importance. They do not bend depending upon the character and conduct of the individual once one has reached that critical disconnect between the exercise of the power and its underlying immigration purposes.
So are you confining the argument?
Sorry, my Lord.
Are you confining the argument about the unavailability of bail to the case where, as you say, this is, where the paragraph 144 point has been passed, or are you not?
My Lord, we say that is this case.
Well, I know you say that, but
we do submit that the requirement that there be a lawful authorization for detention or the ability to lawfully authorize detention is a condition precedent for the exercise of the bail power.
So how does it work if we haven't got to the paragraph 104 point yet?
Yeah.
How does it work then?
In those circumstances, it will obviously depend upon the nature of the error that gives rise to the illegality.
Well, it might simply be an assessment of whether the risk was sufficiently serious to justify continued detention or not, mightn't it?
Sorry, my Lord, I was thinking you were thinking of other kinds of legal error other
No,
than
I'm
the
sorry,
Hardell-Singh.
I wasn't. I was thinking...
We're thinking of a case where you haven't yet reached the backstop.
Yeah.
Yes, but it's otherwise unreasonable.
The balance of the risks and advantages of detention are such that to continue to detain would be unlawful.
Might be, yes.
Or might.
And who decides it?
Yes.
That's why I ask, how does it work until you hit the backstop?
Well, if the detention is unlawful for any of the Hardell-Singh principles, it's not for the statutory purpose, obviously that's closely related to two, or it's evident that in the future a reasonable period will be exceeded, or the Secretary of State has failed to exercise due diligence, we respectfully submit that goes to the lawful power to exercise detention, and it would have the same consequence. What I was... It's not there's no lawful authority for detention. The fact that that may change isn't a problem, because if there's a lawful power to detain the person, then the bail power arises. So it's only predicated on the basis that detention cannot be lawfully exercised. If the scenario arises, as Mr. Tam suggests, well, it may be that the breach of bail alone generates a different question on the balance, then the problem doesn't arise, because if the person can be detained compatibly with the Hardell-Singh principles, then it doesn't offend against the problem that we've identified and the Court of Appeal accepted.
I think he was postulating the case where, if you can imagine it, at the time that the bail is granted, the only acceptable decision would be it's too late to continue detention, though we haven't yet hit the backstop. But then there is an egregious breach of the bail, which alters the judgment of whether detention is justified or not. Now, what's the position in relation to the period that the person has been on bail, and is he in breach of it or not?
If there's a change of circumstance so that detention would be lawful, then the problem simply doesn't arise.
Well, it might, mightn't it? He might have a legitimate complaint, if you're right, that for the past 6 months he's been subject to conditions which it was unlawful to impose.
Well,
Yes, the day before he breaches the bail conditions, he might not be liable to detention the day after. The balance may change. I think that's the point.
well, if during the period that the person is on bail and subject to conditional bail, and the detention is unlawful, then he should not have been placed on bail.
Well, that's what I thought you were saying.
Yes, but sorry, I was addressing a situation that.
Well,
that friend
couldn't it be the other way around? I mean, couldn't detention be lawful unless you can release on bail? In other words, this person, supposing a person is a risk either of committing further offences or of flight, on the face of it, you're entitled to detain them, but you can ameliorate that position by releasing them on appropriate bail. Unless you can release them on bail, you will be authorised to detain. Can you look at it that way around?
Well,
So to speak, the possibility of bail is one which alleviates something which, without bail, would be perfectly lawful.
would be lawful.
Yes, but if there wasn't a possibility of bail, then however hard the personal circumstances, the risk of committing further offences or of flight would justify detention. But once you have the possibility of bail, obviously, then that is the ameliorating factor. Aren't there, in truth, in that situation, alternatives to each other?
There are only alternatives if the detention would be lawful.
Well, it would be lawful if you couldn't impose bail conditions. The
Yes.
fact that you can impose bail conditions, obviously you have to take the lesser, less stringent course. But in a sense, you can't separate the two sides of the coin.
Well, in my respectful submission, the statutory scheme does, because the statutory scheme is underpinned by a clear distinction between the circumstances in which the bail power can be exercised and the temporary admission power can be exercised.
But don't you have to test whether you can detain on an assumption that bail is not possible? Forget about bail. All other things being equal, can we detain? If the answer is yes, then you start to think about whether you can alleviate that position by bail.
I think that's your case, isn't it?
Is that I'm just trying to test how it works conceptually.
If the detention is lawful, then yes, that is correct.
Well, it'd
Then-
be lawful because you're looking at it in the abstract, as forgetting about the possibility of bail.
So your lordship posits the situation not where the detention is lawful and it could be lawfully authorised, but where if you could take into account release on bail, that may mean that detention is lawful.
No. It ceases. On the contrary, it would cease to be something which you could properly impose. Actually, in Hardyall Singh Category 2 type situation, you may Category 2, as I understand it, is looking at the irrespective of the Hardyall Singh period. Assume it hasn't expired. Can you actually keep someone inside? And that, it seems to me, will depend upon whether the sort of inquiry I was suggesting, is this a prima facie case for detention? And if it is, then detention is lawful, but you may be able to mitigate it by releasing on bail.
Yes, and in those circumstances, that is consistent with our case. I think that perhaps what is the proposition that has been grappled with in some of the cases, although without any argument, is where you would only the risks of release, whether that be absconding or offending, can be met by bail conditions, And therefore, when the court releases the person because they've concluded that there's no real prospect of removal, they've imposed bail. Now, in those circumstances, we respectfully submit that is wrong.
Well, why? Because if you were, I mean, it seems to me that without bail, it would be lawful to detain, and all you're doing is adopting a mitigating procedure. That's how I would see the second category being dealt with in a practical way at the moment.
Well, I think just now you were talking about the backstop case, weren't you?
I see. I'm sorry.
But
I missed
what's
that.
worrying us at the moment, Ms. Harrison, is the non-backstop case.
Yeah, fine.
Yes.
Sorry, I hadn't realised we'd switched.
Well, in those circumstances,
Well, we've got two, let's put two possible factual scenarios to you. It's the non-backstop case where you nevertheless, still under Hardiel-Singh, have to consider whether in all the circumstances of the case it is reasonable to detain the person. And it was held in iron, in lumber, that relevant to that question is the risk of absconding and the risk of committing further offences. Yes. Now, that means there may be two possibilities. One is that, notwithstanding the risk of absconding or committing further offences, it is not reasonable to continue to detain this person.
yes,
Or the other alternative is that, bearing those two things in mind, it is so reasonable to continue to detain. Now, if it's the second, well, then it's reasonable to continue to detain, and so the authorisation for detention can be made, and then you have to think, well, but isn't bail the way of managing that situation? In the first of the two situations I put to you, it's not reasonable to continue to detain, notwithstanding, so there could be no authorisation, and if there's no authorisation, there could be no bail.
correct.
Is that how you see it working?
Yes, and
And that could shift from month to month.
And the alternative is temporary admission, which is still
Oh,
conditional.
yeah, well, you understand. We understand that, yes. But we're just trying to tease out this very difficult aspect of the Hardiel-Singh principles. And, of course, it's even worse when you go on to the other dimensions of unlawfulness,
Well, what
like the Kambadzi. Lumber is a very special case, actually. It's a very special situation, but Kambadzi wasn't.
Well, I'll deal with those two
Yes.
separately, but the fact that there may be changes to the question of whether or not the lawful power to detain can be exercised is not a reason for rejecting our arguments. Our position is that if you cannot lawfully exercise the power to detain, the bail power doesn't exist because it's parasitic upon that. But where you can, then bail is an option. So that is our position on that. We submit that in the context of the lumber case, one of the primary reasons why the policy, the secret policy, was offensive requiring all foreign national prisoners on a blanket basis to be detained was because the Hardiel-Singh principles weren't applied properly or at all. And so there never was a proper decision taken on whether to continue the detention of those foreign national prisoners. And it's clear in the Kambadzi context that the question of reviews, detention reviews, go closely to and hand in hand, those are the words that Lord Hope used at paragraph 52, with the authorisation for detention. So if you didn't carry out the review, you haven't authorised the detention. And that's obviously a critical part of the statutory scheme, and I'll come on to take you in detail to it, because it's not only that the person, not only the use of the word detained, but that it has to be under the authority of an immigration officer or the Secretary of State. And if you haven't actually exercised your power, you haven't given an authority, then obviously that goes centrally to the power whether the power has been lawfully exercised.
Sarah, I'm awfully sorry to gnaw away at the same bone, but I'm sorry I'm not there yet.
Yes.
Let's take this example and see if it helps. If it doesn't, throw it out of the window. It's a non-backstop case, so we haven't got to the point where any further detention would offend Hardiel Singh because there's no longer any reasonable prospect within a sensible time of deporting, okay? So it's a non-backstop case, and somebody is considering whether to detain or not. And the problem is that the allegation is of pestering a child. And you are told that there is an absolutely cast iron condition which you can attach to a bail order which will obliterate that risk. Now then, at that point, is detention lawful or not?
In those circumstances, my lord, the detention is a lawful detention.
Even though you wouldn't, in fact, direct it, you would instead grant bail with the condition which obliterates the risk.
Yes.
I see. Well, if that's what you're saying, then I think I do understand.
Sorry.
It's, as my lord was saying, you have to consider that issue irrespective of the power to grant bail. And having considered that issue, then you consider whether actually bail is an acceptable alternative.
So detention,
Yes.
detention when you really ought to be granting bail is still not for that reason necessarily unlawful.
Yes, my lord.
Okay.
Yes, my lord.
Got it. Thank you very much.
There were just, before I just go on to the statutory scheme, 2 points to emphasise. One was, of course, what that has already been agreed, that it is common ground that bail conditions can in fact amount to not only to a deprivation of liberty for Article 5 purposes, but in fact to effective incarceration or confinement.
But why does this matter? I mean, of course they can in some situations, but we're dealing with a thing in general terms, aren't we? You don't. If you
Yes,
take a special case, it doesn't help us test the general principle.
Well, in my respectful submission, it does, because the Secretary of State is claiming a power that includes a power to put somebody under 24-hour house arrest, as has occurred in the Special Immigration Appeals Commission, in circumstances where the person could not be lawfully detained.
Yes, well, maybe that particular power is illegitimately claimed, but what we want to know is whether there's any power to impose bail even without conditions.
Well, first of all, if we're looking at
I'll
deal with both,
case,
but we are dealing with generality and on the assumption that this power could be exercised of bail up to and including 24-hour house arrest for those who couldn't be lawfully
Well, maybe it couldn't.
detained.
I mean, maybe it couldn't, and that you're just taking an extreme case, or the Secretary of State is taking an extreme case which couldn't be sustainable. It doesn't help on the general principle.
Well, I only want to. I'll come back to the the other side to that, which is conditional bail. But for your lordship's note, there is an example of a 24-hour bail order in volume 8, 92, 7, and that's the case of U. In respect of the other end of the scale, where it would be unconditional bail, we do respectfully submit that that scenario too offends against the principle, because ultimately, when one imposes bail, it has to be to a time and a place, as is clear from the statute in paragraph 22 and 29. It contemplates, for a number of reasons, surrender of the person, whether that simply be at the designated time or in order for changes to be made to their bail. And if you cannot surrender because you can't exercise the power to lawfully detain, then it fundamentally frustrates the whole purpose of bail. And so we respectfully submit that even in the context of unconditional bail, where the only requirement is that you have to surrender for it at a time and a place, that's impermissible because that presupposes the underlying authorization for detention, so that precisely at that moment, the power to detain could be exercised. And if you do not have a power of surrender, then it's difficult to see how this is still being properly characterized as bail. And we come on and look at the cases Mr. Tam referred you to in brief, to the case of AR Pakistan and also the Stellato case, which we respectfully submit do give an answer, and it's not the answer that Mr. Tam gave as to the correct approach, because bail is finite. It is always to a time and a place. It is always underscored by the prospect of having to surrender when the deportation proceedings come to an end at a date, and so it simply cannot work if you cannot be lawfully detained. There are, of course, within that spectrum, a very wide range of severe interference with liberty that can be imposed on bail but not on temporary admission. And whilst Mr. Tam seeks to suggest that we therefore ultimately are complaining about the terms of the bail conditions that were imposed, that is not so. Our case is obviously and always has been that the kind of intrusive, extensive bail conditions that B was subjected to, which included long curfews, a very tight boundary, restrictions on visitors, restrictions on communications, etc., are simply not available unless you can otherwise lawfully detain the person. And we fully accept that in circumstances where you could otherwise lawfully detain a person, it's absolutely acceptable for there to be severe restrictions as an alternative to detention, including the 24-hour house arrest conditions that have been imposed. But that is predicated always on the fact that there was a lawful alternative of detention. And so where that lawful alternative no longer exists or cannot be lawfully exercised, then those very severe conditions of bail of the type that are typical in SIAC, they are not available, and that Parliament intended in those circumstances still a regime that allows for significant intrusion on liberty, including electronic tagging and residence conditions, no recourse to public funds, not working, not being a student, but they are of a fundamentally different category than are available if you are imposing bail as an alternative to lawful custody. Those then are my opening submissions, save for one further reference in respect of the nature of the risk that my client is said to pose. And whilst I don't, of course, want to go behind any of the findings that were made in the past, the Commission's conclusions as of April 2014 was that he was a negligible risk to national security. And the case inevitably by 2014, B having first been detained under the Anti-Terrorism, Crime and Security Act 2001, was historic in the extreme, And on that basis, the Special Immigration Appeals Commission concluded that it was a negligible national security risk. Of course, that's not to say that there may be other cases where the risk is more significant, but on the facts of this case, this power, the purposive approach in terms of risk management that underlies much of my learned friend's submissions is being sought in the context where obviously what would otherwise be the most pressing risk, a national security risk, was on the facts negligible. And again, that illustrates that there isn't a way in which to carve out this possibility of indeterminate or indefinite bail disconnected from the lawful authorization for detention to any particular category of case. A learned friend may say, well, it will generally be exercised if the person's a bad lot, but that's not the reality of the situation, either in the context of the specific case, but also in the context of the exercise of administrative powers of detention more generally. And we have set out in our written case references to the spectrum of cases that would fall within this power. And they do, we respectfully submit, range from it's at, sorry, my lady, my lord, it's at MS 4236 in our written case 39 to 41. And it does range across the board from asylum seekers, overstayers, as well as obviously to other forms of those who've committed criminal conduct. But within that, there is recognised to be a very significant cohort of highly vulnerable people who are detained under immigration powers. And whatever the overall numbers, there is invariably a significant proportion of asylum seekers, victims of torture, victims of human trafficking. And I don't ask you to take it up, but a good source of the sorts of cases that are routinely detained are in a recent decision of Mr. Justice Ousley, the medical justice case. It's referred to on footnote 47, volume 6, tab 64. And the cases, it dealt with 9 cases of individuals who had been detained, all of whom were victims of torture and were being detained essentially whilst their claims for asylum were being processed, although they were also, some of them, overstayers. But they do illustrate that quite clearly that the court should not proceed upon the basis that a power of effectively indefinite detention would only be limited to a very, very small category of highly dangerous people, because that's not likely to be the reality at all. And in terms of the paragraph references that dealt with the summary of cases, it's MS 2408 2412, paragraphs 57 to 73. My lady, my lords, if I can now go to the statutory scheme, and I know that my learned friend has taken you to some key parts of it, but if we can just go back to look more closely at the language that's used. Because it is our respectful submission that the statute is clear in supporting the propositions that we advance. If we go first then to Schedule 2 and paragraph 16, MS 717, And 16.1 contains common features to the subsequent powers, and it is that the person may be detained under the authority of an immigration officer pending his examination on a decision to give or refuse him leave to enter. Likewise, 1A may be detained under the authority of an immigration officer pending completion of an examination or decision to cancel his leave. 1B, again, it's detained under the authority of an immigration officer. And then 16.2, if there are reasonable grounds for suspecting that a person is someone in respect of whom directions may be given under any of paragraphs 8, 10A, 12 to 14, that person may be detained under the authority of the immigration officer. And we respectfully submit that, and as the Court of Appeal accepted, that when one is construing this statutory provision, and we'll go on to look at how the language is replicated elsewhere, detained and under the authority of an immigration officer require it to be lawfully detained under lawful authority of an immigration officer. And the learned friend's submission that detained and or under the authority of an immigration officer can mean unlawfully detained or unlawful authority of an immigration
Or without any authority at all, as I understood his case.
and I was going to say that, and without any authority at all, which is the circumstances in this case, from the 13th of February 2014, then that is plainly impermissible, would require implication not only of additional words, but actually that Parliament intended that the power of detention and the authority, under the authority of an immigration officer, could be unlawfully. And it only needs to be stated to respectfully see why that cannot possibly have been Parliament's intention, and that's why the Court of Appeal used those strong words, extraordinary, if that really was what Parliament had intended. It cannot be irrelevant to the power to detain as to whether or not it's exercised lawfully or unlawfully, but that must be the necessary implication, because when we come to look at the power to impose bail, in paragraph 22, it is referenced back to the substantive provision. And so if your lordships and my lady go to para 22, MS page number 724, you'll see clearly there, 22.1, the following, namely, a person detained under paragraph 16.1 above pending examination, a person detained under 16.1a, a person detained under paragraph 16.2.
Your case is really that what Mr. Tam is seeking to do is to write in the word purportedly.
Well, yes, he wants to do that, but he also expressly says he wants to say unlawfully.
Well, it's the same thing, isn't it? Purportedly.
Yes.
He says you want to put unlawfully in.
Yeah.
I want to put
lawfully.
I want to put lawfully in,
Yep.
which I hope that puts me on the right side,
And he
constitutionally,
But you
as
would
well
say,
as...
you would say you don't have to put lawfully in because you aren't in fact detained under paragraph 16 unless it's you're within paragraph 16.
16 tells you when you can do it.
Exactly. Yes, and I was going to come on to that when we come to look at the significance of the reliance on Kadir and the wording that's used for temporary admission, which is precisely the words liable to be detained, which do have a more permissive scope, and following the House of Lords judgment do in fact allow for temporary admission, not detention, but temporary admission, if you if you're liable to be detained.
Well, Kadir really says you're detained under paragraph 16 you may be detained under paragraph 16 and forget about Hardiel Singh in that context, doesn't it?
It's not.
least forget about
We'll
the
come
time
on to
limit.
look at the case because we haven't looked at it. But the critical question in Kadir was not about the power to detain. It was about the power to grant temporary admission, which is under a different provision. And it may be that it's the appropriate time to deal with that now. But if I could just take you through the statutory scheme. We've seen para 22, and
Yes,
we know that paragraph 29, which is at MS page number 753, is the power to grant bail pending an appeal. It was this power that was exercised in B's case. And again, you'll see that there is a clear reference back to the substantive provisions. That's in 29.1, and you'll see, and is for the time being detained under part 1 of this schedule. He may be released on bail in accordance with this paragraph. And then sets out ancillary provisions relating to release on recognizance, which we'll come back to. But again, 29.1 is expressly predicated back to the substantive detention provisions, which, for the reasons that we've been discussing, could only mean lawful detention under paragraph 16. If we then look at the alternative language before we turn to the case of Kadir, and it's paragraph 21, and that's MS page number 723. And critically makes clear that a person liable to detention or detained under paragraph 16.1, 1A or 2, may, under the written authority of an immigration officer, be temporarily admitted to the United Kingdom without being detained or be released from detention, but this shall not prejudice a later exercise of the power to detain him. So the statute specifically using a materially different set of words, liable to detain, contrasting with detained when it comes to temporary admission. And you'll see that the effect of temporary admission, again, we say distinct from bail, is that the person who is on temporary admission is at large in the United Kingdom, but he can be subject to certain conditions, restrictions as to residence, employment and occupation, and as to reporting, as may from time to time be notified. But it's a different concept that's used and is at large. And it is that also that it's recognised that the grant of temporary admission, although it's not a formal leave to enter, it's a status of lawful presence in the United Kingdom. And again, distinct from bail, which has no immigration status consequences, unlike temporary admission.
Is it worth looking also at paragraph 17?
I was going to show you that next, yes, but just because that's the alternative. And again, as my lady rightly anticipates, that you'll see in paragraphs 17 and 18 that there is again a deliberate use of the language of paragraph of liable to be detained in 17. And what this power does is allow for a specific power to arrest a person on temporary admission if there are reasonable grounds for suspecting the person liable to be arrested under this paragraph is to be found at any premises. And you'll see that it's by warrant, authorising any immigration officer or constable to enter, if need be by reasonable force, and sub 17.3 applies where an immigration officer or constable enters premises and detains a person on the premises. You'll then see that there's the possibility to use reasonable force, in that context.
Paragraph 17.1 appears to postulate that if a constable or an immigration officer sees someone who's, in respect of whom there is still some prospect of removal, they may be arrested. Well, presumably one has to read into that the Hardiel-Singh qualification that they shouldn't be arrested if there's no reasonably immediate prospect of removal. So the officer or immigration officer is making quite an interesting choice.
Well, my lord, we would submit that it's not the Hardale-Singh principle because it's liable to be detained.
Right.
That's Kadir.
This is
some
just
prospect.
this is the authorisation of arrest
And it's
Yes.
with
arrest.
a view to possible detention
Yes.
rather than detention.
And
Yes, it's not,
I see.
it's not actual
Yes.
detention at
Yes,
all.
right.
No,
So it's not-
and the
Well, that's the critical point.
Yes, I see.
Liable to be arrested under liable to be detained under paragraph 16 is distinct from being detained under paragraph 16.
Exactly, my lord.
Absolutely.
And its purpose, as I understand it, I don't think it's used very often, this power, but it is if circumstances change and if you needed to locate a person who has been on temporary admission, say, for example, to remove them, because you do not have the underlying authorisation for detention as you do with bail, you need a specific power in order to
Oh,
take
if you
some
come
coercive
across an
steps.
overstayer,
Yes,
if you come across an overstayer, you've got power to arrest them
yes,
and then decide whether they should be detained.
detained, exactly,
Yeah.
my lady. But it,
Well, I think that probably happens quite a lot.
I
No, but we've certainly encountered examples
yeah.
of it in this court.
Perhaps it's just that I've never seen a document that says it's under this power, but that may be just my lack of information.
no.
But I accept that it has a definitely utility and function, and it's one that is predicated on liability to be detained, and it requires some express power. But again, it's Parliament using specifically materially different language to carve out what can and cannot be done, depending upon whether or not the person it can be detained or is only liable to be detained.
What
Then
happens
we-
once they've been arrested? Does the statute say where they're taken and who decides whether they should then be detained?
I don't think it does. My understanding is that I thought it said that, is that it would give a power, for example, to serve a particular notice on the person, for example, overstaying or illegal entry, and it may be a prelude actually to their lawful detention under paragraph 16. Yeah,
Yes.
but
presumably
it's the
police-
Home Office who would have to decide that question.
Yes, I mean, the police would arrest, detain under arrest, and then refer it to the Home Office, and an immigration officer would take the paragraph 16 decision.
Yeah.
Yes, that's right.
Yeah.
That's right.
And he would apply the Hardiel-Singh if it had got to that point. If it was, in most cases, it wouldn't be. It'd be someone who was.
Probably about to be
Yeah,
imminently
yeah.
removed, most likely. And then if we do look at paragraph 18, yes, I'm great. Mr. Fordham says that you would have that, obviously have that power if it was pending removal under 2B. So that there's nothing in this scheme that becomes unworkable in terms of the distinction between those liable to be detained and those who are detained. They can still be subject to immigration control measures and enforcement, but there's a fundamental recognition in the statute that you do something different for a person who is liable to be detained as opposed to someone who can be detained, and that's because of the underlying lawful power and authorisation to detain someone. So if we look then at paragraph 18, and this is an ancillary power that allows for steps to be taken where to facilitate removal. So for that reason, we respectfully submit it makes sense that Parliament chose detained and detained meaning lawfully detained, i.e. including pursuant to the Hardell-Singh principles, because while ever the detention is for removal, and removal is in reasonable prospect, then inevitably immigration officers and others can take steps to facilitate that lawful removal. That would include 18.2 by photographing, measuring, or otherwise identifying the person, biometric information, etc. And you'll see at 3, that's concerned with essentially obtaining travel documents for the person's return, so he can be required for the purpose of ascertaining his citizenship or nationality, or making arrangements for his admission to a country or territory other than the United Kingdom, or where he is required to be for any other person, and that he will be deemed to be in legal custody when he is detained under paragraph 16, or is being removed in pursuance of subparagraph 3. And 2 points to make about that. Again, this is all about the facilitating of the process for removal. Hardell-Singh lawful detention is predicated on the fact that you have a person who you can remove within a reasonable period of time. And as we see at paragraph 18.4, for those who are at any time when he is detained under paragraph 16, he will be deemed to be in legal custody, not purported legal custody or possibly unlawful illegal custody, but legal custody. And we see again, if we go over at 720, that there are additional other powers of arrest that again are all predicated upon being detained. So coercive powers in 18A to search a person, for example, in 18A1. And so on, so that the statute between 18 and 20 delineates particular powers that can be used depending on whether the person is detained or if they're liable to be detained. And we see that in paragraph 19 and 20. So because of that, before looking at the power in 24, which is obviously an important power, it may be appropriate at this point to look at the case of Kadir in the volume 1, 2. Sorry.
No, it's...
Sorry, I was looking at AM. It's tab 13. I'm grateful to my learned friend. And we'll come back to how Baroness Hale summarised the position, but succinctly at paragraph 4 in a moment. But if we can look at the lead judgment given by Lord Brown, which is at 1074. And the facts of the case were that there had been individuals of Iraqi Kurdish origin who, although not entitled to asylum, could not be practically removed back to Iraq because of the lack of a practical means to secure their return to the country. And that had led to very long periods of time upon which individuals had been on temporary admission. And Mr. Blake, on behalf of the individuals, had submitted that because the power of temporary admission is predicated upon detention, and you could no longer lawfully detain the person, therefore you couldn't impose temporary admission. And you'll see the question set out in the judgment of Lord Bown at paragraph 18, 1077. You'll see that the basis upon which it was concluded that Mr. Kadir was someone who was liable to be detained, even though he couldn't be physically removed from the country at all, is at the top of 1078. The appellant was somebody liable to detention under paragraph 16, because he was an illegal entrant. So therefore, temporary admission could be authorised. And then it sets out below that what the submission of Mr. Blake was on behalf of the individual. And his argument was that the appellant could not lawfully be detained because of the practical difficulties in making arrangements for his removal from the United Kingdom. He was not therefore liable to detention. And at paragraph 20, there was reference to statutory provisions that had reversed the High Court ruling in the favour of Mr. Kadir, that he could not be admitted to temporary admission because he couldn't be lawfully detained. That's set out at 67, again a retrospective provision that sought to make good a ruling of the court to the contrary. But what's important and what's recognised by Lord Brown in paragraph 20 is that the notion of liable to be detained does not affect provisions like paragraph 16.2. And if you see that at F on 1078, does not affect provisions like paragraph 16.2 of Schedule 2, the detention power, but rather provisions like paragraph 21, which give power to temporarily admit those liable to detention. In short, the section recognises that it is one thing to detain a person during what may be a long delayed process of removal, quite another to provide for his temporary admission during such delays. There's then at 21 setting out of the Hardale-Singh principles and other references to other cases, Mahmood and Tanti Lai, between 22 and 24, which were the cases that Mr. Blake relied upon, 4 in all going to the question of when one can lawfully detain someone compatibly with Hardale-Singh principles. And Lord Brown makes this observation at 25. In each of those 4 cases, the court was concerned only with whether the applicant was still lawfully detained. In none of them did the court consider the consequences of their release from detention. Paragraph 2, 5 and 6 of Schedule 3 deals with a person liable to be detained under paragraph 2.3 while he is not so detained, by providing that he shall be subject to such restrictions as to residence, etc. I doubt it crossed the minds of anyone involved in those cases that the applicants on release might not have been properly made subject to such restrictions, but instead should have been released unconditionally. Yet that necessarily must be the effect of Mr. Blake's argument. And then we have important paragraph where he summarises what was the submission that was made. At 26, and then the judgments of the courts below. But you'll see at paragraph 31 on 1082 the way in which the court addressed this question and adopted reasoning of my Lord Mance. making the distinction between circumstances in which a person is potentially liable to detention and can properly be temporarily admitted, and the circumstances in which the power to detain can, in any particular case, properly be exercised. So that key distinction is from the reasoning of my Lord at paragraph 30 between 74 to 76, but in particular 75 on 1081. And then Lord Brown made these observations: it surely goes without saying that the longer the delay in effecting his removal, the more difficult will it be to justify his continued detention meanwhile. But that is by no means to say that he does not remain liable to detention. What I cannot see is how the fact that someone has been temporarily admitted rather than detained can be said to lengthen the period properly to regard it as pending his removal. And then the next paragraph, paragraph 32, construing the word pending, that it's a preposition, not an adjective. Paragraph 16 does not say the removal must be pending, still less that it must be impending. So long as the Secretary of State remains intent upon removing that person, and there is some prospect of achieving this, paragraph 16 authorises detention meanwhile. Plainly, it may become unreasonable actually to detain the person pending a long delayed removal, i.e. throughout the whole process until removal is finally achieved. But this does not mean that the power has lapsed. He remains liable to detention, and the ameliorated possibility of his temporary admission in lieu of detention arises under paragraph 21. And the key paragraph then is at paragraph 33, making the distinction. To my mind, the Hardall-Singh line of cases says everything about the exercise of the power to detain, when properly it can be exercised and when it cannot, nothing about its existence. True it is that in Tam T. Lam, the Privy Council concluded that the power itself had ceased to exist, but that was because there was simply no possibility of the Vietnamese government accepting the applicant's repatriation. It was effectively conceded that removal in that case was no longer achievable. Once that prospect had gone, detention could no longer be said to be pending removal. I acknowledge that in the first passage of his judgment set out in paragraph 24, Lord Brown Wilkinson had correctly posed the question pending removal, then used the expression if removing is not pending. That, however, can only have been a slip. And none of this, of course, is to say that the regime governing temporary admission is other than harsh. That harshness is sanctioned by Parliament. It cannot affect the true construction and application of paragraph 16.2 and 21 of the Schedule 2. Its only possible relevance would be to the exercise of the Secretary's undoubted discretion, irrespective of the legal position, at any time to grant ELR, exceptional leave to remain. So we see that the court has made a clear distinction between the existence of the power to detain and its lawful exercise. Where the power exists but cannot be lawfully exercised, then Parliament has used the words liable to detention, and that is obviously contrasted with paragraph 16 and other paragraphs where Parliament has used the word detained. The two cannot be encompassed. The Court of Appeal was correct to recognise there was a material distinction, and that Kadir was not apt, and its reasoning was not apt, to be read over to the different and distinct power to detain. And although my learned friend puts his case differently than the way that it was put below, which was fairly and squarely on Kadir is the answer to it's now should be applied by analogy, we respectfully submit that cannot be correct. We do say if one wanted to see this point crystallised, then it would need to only to look at section 61.3 of the of the 2016 Act, which itself substitutes the words liable to be detained for detained, to see what sort of language would be necessary to achieve what Mr. Tam seeks to imply into the pre-existing 1971 Act. And for all the reasons that were given by the Court of Appeal in paragraphs 27, 29, we ask the Court to reject any reading over or reading in or applying the notions of liable to be detained to the different statutory language of detention and mark the number of times in Mr. Tam's submissions where he wanted to emphasise the power to detain continues, as opposed to the power to detain can be lawfully exercised. Power exists when you're liable to be detained. That's clear from Kadir, but it cannot be lawfully exercised under the provisions relating to the substantive powers to detain in paragraph 16 and under Schedule 3.
That's beginning to sound like a convenient moment, Miss Harrison.
Well, I was just about to go back to paragraph 24.
Oh, if you want to, by all means.
I'm happy to do so if it would assist, and I know that it's been troubling my Lord Hodge.
Yes, well,
So if
yes,
we
do
it's at 727. Paragraph 24 being the power conferred on an immigration officer or a constable to arrest without a warrant a person who has been released by virtue of paragraph 22, so somebody who's on bail, in a number of circumstances. First, if he has reasonable grounds for believing that the person is likely to break the conditions of his recognizance or bail bond, that he will appear at the time and place required, or to break any other condition of it, or has reasonable grounds to suspect that the person is breaking or has broken any such conditions. So it's both it's a possible and actual existing breach of bail, and then B, in respect of sureties has been taken, a recognizance with sureties has been taken, he is notified in writing by any surety of the surety's belief that that person is likely to break the first mentioned condition, and of the surety's wish for that reason to be relieved of his obligations as a surety. And so, although we'll come on to the older cases, it's important to recognise that in this particular statutory context, there is still very much a recognition in 24(1)b of the role of sureties, not going to be in custody of the surety in their home, but that the surety's concerns about whether or not the person is likely to breach the first condition, that being the condition to appear at a time and a place, is something that gives rise to a power to arrest without warrant. We see then that the consequences of that is at 24(2), that he be brought before an immigration officer within 24 hours after the time of his arrest, or if that is not practicable, within 24 hours before Justice of the Peace or the Sheriff in Scotland, if required by such a condition to appear within those 24 hours before an immigration officer, shall be brought before that officer. So it's a specific power in 24(1) to arrest the person. We do not submit that 24(1) itself rests upon lawful authorization for detention, insofar as 24(1) gives a power of arrest in those circumstances. But what we do respectfully submit is critically important is what happens once you've brought the person before the first tier tribunal, the immigration officer in the first tier tribunal, and what will that individual do if it is established that the person was or is or may have breached their bail conditions. And you'll see that if the opinion of that person, if in the opinion that person has broken or is likely to break any condition on which he was released, may either direct that he be detained under the authority of the person by whom he was arrested or released on his own recognizance. And so again, we get the important statutory language of detained and under the authority of the person by whom he was arrested, and that would either be an immigration officer or a constable, and the latter obviously contemplating that there may be criminal proceedings for breach. But critically, the sanction for breach of bail conditions in 24(3 includes that the person will be detained and under the authority of such a person. The immigration officer would only have authority to detain in circumstances where there was a lawful power both in existence and which could be exercised under paragraph, the substantive provisions. And so it expressly refers back to the underlying authority for
Yes.
detention.
Yes, I mean, in the context of the criminal law, I think a breach of a bail condition can itself be an offence.
Yes, it is also an offence under these provisions, under paragraph 24 of the 1971 Act itself, for breach of conditions of temporary admission. Is it for bail as well? No. Sorry, that's for breach of temporary admission. But here the remedy is dealt with in 24.
And this is the exclusive remedy, as far as you know.
Yes.
So,
Yes.
so we have the Secretary of State saying that he needs to impose bail with conditions, but if we are post-long stop, Hardy Singh, you can't actually enforce the conditions.
No, you can't. And we respectfully submit that the fact that bail on my learned friend's case must continue indeterminately and indefinitely without any possibility, even in circumstances of breach, for the person to be redetained, fundamentally exposes why his construction of the statute makes no sense and frustrates the key provisions, which is the provisions to release on bail subject to conditions, and obviously the sanction that if you breach them, you'll go back into detention. And if you were positing the risk management scenario, how does that assist the Secretary of State's risk management functions if the person could, with impunity, breach their conditions but not be put back into detention?
That's obviously right, but I'm just wondering, Ms Harrison, whether detention under 24(3 following a breach of bail, I mean, 24 is 1 arrest, 2 production, 3 consequences, isn't it?
Yes, that's right.
Okay, and 24(3 is a new form of detention. It's not reinstating the paragraph 16 detention. It's a new form of detention under the authority of the person by whom the arrest is being carried out. And I'm just wondering whether that makes any difference.
Well, my lord, we respectfully submit that the immigration officer's authority is of detention is under paragraph 16.
Well, it isn't, you see. I don't think.
But even if we were wrong about
This isn't in any event an immigration officer. This is a JP or the first tier tribunal or the Scottish
yes,
sheriff.
no, but they direct that he be detained under the authority of. So the court itself, whether it's a JP or a sheriff, doesn't have its own jurisdiction to detain. It has to be under the authority of a public official with the power to detain. That's what under the authority of the person.
I see. You say that assumes a paragraph 16 authority.
And
Yes.
I think when I discussed this with Mr. Tam, he accepted that paragraph 3, detention, had to be a detention authorised outside paragraph 24.
Yes.
There's little,
Yes.
little
and then
too.
if we go on to look at the case of sorry, I've forgotten the name of the Spiccato. Sorry.
Stellato.
Stellato. Sorry. Then we see how this makes sense, and I'll take your lordship,
Yes,
my lady, to that.
It was in that context, the context of Stellato.
Yes, it was
that
in
the power, there has to be an
Underlying.
extraneous part of detention which is exercisable for the sheriff or the justice of the peace or the tribunal to impose a sanction on the person breaching his conditions.
Exactly, my lord. We endorse that proposition and say that must be right. The Court of Appeal was correct in concluding that the grant of bail itself wasn't an authorisation for detention. To the contrary, It was an order for your release, and it can only be the underlying power that led to you being put on bail in the first place.
Well, I'm sorry, Miss Harrison, that I allowed you to go into that. Because we've gone way over the deadline.
Sorry.
And some of us have another meeting
I apologise.
that we must go to. So do excuse us. We'll look forward to hearing from you further at 10:30 tomorrow morning. Court is now adjourned.